The videos on this channel are for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Watching of these videos or links contained within the site do not create an attorney-client relationship between the channel and the user or browser. Let's get started. Rule 1.0.1 Terminology. For California Rules of Professional Conduct. A. Belief or believes. Means that the person involved actually supposes the fact in question to be true. A person's belief may be inferred from circumstances. B. Reserved. C. Firm or law firm. Means a law partnership, a professional law corporation. A lawyer acting as a sole proprietorship. An association authorized to practice law. Or lawyers employed in a legal services organization or in the legal department, division, or office of a corporation, of a government organization, or of another organization. D. Fraud or fraudulent. Means conduct that is fraudulent under the law of the applicable jurisdiction and has a purpose to deceive. E. Informed consent. Means a person's agreement to a proposed course of conduct after the lawyer has communicated and explained 1. The relevant circumstances and 2. The material risks, including any actual and reasonably foreseeable adverse consequences of the proposed course of conduct. E1. Informed written consent. Means that the disclosures and the consent required by paragraph E must be in writing. F. Knowingly, known, or knows. Means actual knowledge of the fact in question. A person's knowledge may be inferred from circumstances. G. Partner. Means a member of a partnership, a shareholder in a law firm organized as a professional corporation, or a member of an association authorized to practice law. G1. Person. Has the meaning stated in Evidence Code Section 175. Person includes a natural person, firm, association, organization, partnership, business trust, corporation, limited liability company, or public entity. H. Reasonable or reasonably. When used in relation to conduct by a lawyer means the conduct of a reasonably prudent and competent lawyer. I. Reasonable belief or reasonably believes. When used in reference to a lawyer means that the lawyer believes the matter in question and that the circumstances are such that the belief is reasonable. J. Reasonably should know. When used in reference to a lawyer means that a lawyer of reasonable prudence and competence would ascertain the matter in question. K. Screened. Means the isolation of a lawyer from any participation in a matter, including the timely imposition of procedures within a law firm that are adequate under the circumstances. 1. To protect information that the isolated lawyer is obligated to protect under these rules or other law, and 2. To protect against other law firm lawyers and non-lawyer personnel communicating with the lawyer with respect to the matter. L. Substantial. When used in reference to degree or extent means a material matter of clear and weighty importance. M. Tribunal. Means 1. A court, an arbitrator, an administrative law judge, or an administrative body acting in an adjudicative capacity and authorized to make a decision that can be binding on the parties involved, or 2. A special master or other person to whom a court refers one or more issues and whose decision or recommendation can be binding on the parties if approved by the court. N. Writing or written. Has the meaning stated in Evidence Code Section 250. Assigned writing includes an electronic sound, symbol, or process attached to or logically associated with the writing and executed, inserted, or adopted by or at the direction of a person with the intent to sign the writing. Comment 1. Firm or law firm. 1. Practitioners who share office space and occasionally consult or assist each other ordinarily would not be regarded as constituting a law firm. However, if they present themselves to the public in a way that suggests that they are a law firm or conduct themselves as a law firm, they may be regarded as a law firm for purposes of these rules. The terms of any formal agreement between associated lawyers are relevant in determining whether they are a firm, as is the fact that they have mutual access to information concerning the clients they serve. Comment 2. 2. The term of counsel implies that the lawyer so designated has a relationship with the law firm, other than as a partner or associate, or officer or shareholder, that is close, personal, continuous, and regular. Whether a lawyer who is denominated as of counsel or by a similar term should be deemed a member of a law firm for purposes of these rules will also depend on the specific facts. Compare People ex rel. Department of Corporations v. Speedy Oil Change Systems Incorporated. 1999, with Chambers v. K. 2002. Comment 3. Fraud. 3. When the terms fraud or fraudulent are used in these rules, it is not necessary that anyone has suffered damages or relied on the misrepresentation or failure to inform, because requiring the proof of those elements of fraud would impede the purpose of certain rules to prevent fraud or avoid a lawyer assisting in the perpetration of a fraud, or otherwise frustrate the imposition of discipline on lawyers who engage in fraudulent conduct. The term fraud or fraudulent when used in these rules does not include merely negligent misrepresentation or negligent failure to apprise another of relevant information. Comment 4. Informed consent and informed written consent. 4. The communication necessary to obtain informed consent or informed written consent will vary according to the rule involved and the circumstances giving rise to the need to obtain consent. Comment 5. Screened. 5. The purpose of screening is to assure the affected client, former client, or prospective client that confidential information known by the personally prohibited lawyer is neither disclosed to other law firm lawyers or non-lawyer personnel nor used to the detriment of the person to whom the duty of confidentiality is owed. The personally prohibited lawyer shall acknowledge the obligation not to communicate with any of the other lawyers and non-lawyer personnel in the law firm with respect to the matter. Similarly, other lawyers and non-lawyer personnel in the law firm who are working on the matter promptly shall be informed that the screening is in place and that they may not communicate with the personally prohibited lawyer with respect to the matter. Additional screening measures that are appropriate for the particular matter will depend on the circumstances. To implement, reinforce and remind all affected law firm personnel of the presence of the screening, it may be appropriate for the law firm to undertake such procedures as a written undertaking by the personally prohibited lawyer to avoid any communication with other law firm personnel and any contact with any law firm files or other materials relating to the matter. Written notice and instructions to all other law firm personnel forbidding any communication with the personally prohibited lawyer relating to the matter, denial of access by that lawyer to law firm files or other materials relating to the matter, and periodic reminders of the screen to the personally prohibited lawyer and all other law firm personnel. Comment 6. 6. In order to be effective, screening measures must be implemented as soon as practical after a lawyer or law firm knows or reasonably should know that there is a need for screening. This has been Rule 1.0.1 terminology for California Rules of Professional Conduct. Thank you for watching. If you liked this video and want to see more, please hit that like, subscribe, click the bell, comment.